The right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act, 2013. Chapter 10. Payment. Section 77. Payment of compensation or deposit of same in authority. 1. On making an award under Section 30. The collector shall tender payment of the compensation awarded by him to the persons interested entitled thereto according to the award and shall pay it to them by depositing the amount in their bank accounts unless prevented by someone or more of the contingencies mentioned in subsection 2. 2. If the person entitled to compensation shall not consent to receive it, or if there be no person competent to alienate the land, or if there be any dispute as to the title to receive the compensation or as to the apportionment of it, the collector shall deposit the amount of the compensation in the authority to which a reference under Section 64 would be submitted, provided that any person admitted to be interested may receive such payment under protest as to the sufficiency of the amount. Provided further that no person who has received the amount otherwise than under protest shall be entitled to make any application under subsection 1 of Section 64. Provided also that nothing herein contained shall affect the liability of any person, who may receive the whole or any part of any compensation awarded under this Act, to pay the same to the person lawfully entitled thereto. Section 78. Investment of money deposited in respect of lands belonging to person incompetent to alienate. 1. If any money is deposited in the authority concerned under subsection 2 of Section 77 and it appears that the land in respect whereof the same was awarded belonged to any person who had no power to alienate the same, the authority concerned shall order the money to be invested in the purchase of other lands to be held under the like title and conditions of ownership as the land in respect of which such money shall have been deposited was held, or b. If such purchase cannot be effected forthwith, then in such government of other approved securities as the authority concerned shall think fit, and shall direct the payment of the interest or other proceeds arising from such investment to the person or persons who would for the time being have been entitled to the possession of the said land, and such monies shall remain so deposited and invested until the same be applied. 1. In the purchase of such other lands as aforesaid, or e. in payment to any person or persons becoming absolutely entitled thereto. 2. In all cases of money deposited to which this section applies, the authority concerned shall order the costs of the following matters, including therein all reasonable charge and expenses incident thereon, to be paid by the collector, namely a. The costs of such investments as aforesaid. b. The costs of the orders for the payment of the interest or other proceeds of the securities upon which such monies are for the time being invested, and for the payment out of the authority concerned of the principal of such monies, and of all proceedings relating thereto, except such as may be occasioned by litigation between adverse claimants. Section 79. Investment of money deposited in other cases. When any money shall have been deposited in the authority concerned under this Act for any cause other than the causes mentioned in Section 78, the authority may, on the application of any party interested or claiming an interest in such money, order the same to be invested in such government or other approved securities as it may think proper, and paid in such manner as it may consider will give the parties interested therein the same benefit from it as they might have had from the land in respect whereof such money shall have been deposited or as near thereto as may be. Section 80. Payment of interest. When the amount of such compensation is not paid or deposited on or before taking possession of the land, the collector shall pay the amount awarded with interest thereon at the rate of 9% per annum from the time of so taking possession until it shall have been so paid or deposited, provided that if such compensation or any part thereof is not paid or deposited within a period of 1 year from the date on which possession is taken, interest at the rate of 15% per annum shall be payable from the date or expiry of the said period of 1 year on the amount of compensation or part thereof which has not been paid or deposited before the date of such expiry. Chapter 11. Temporary occupation of land. Section 81. Temporary occupation of waste or arable land. Procedure when difference as to compensation exists. 1. Whenever it appears to the appropriate government that the temporary occupation and use of any waste or arable land are needed for any public purpose, the appropriate government may direct the collector to procure the occupation and use of the same for such terms as it shall think fit. not exceeding 3 years from the commencement of such occupation. 2. The collector shall thereupon give notice in writing to the person interested in such land of the purpose for which the same is needed, and shall, for the occupation and use thereof for such term as aforesaid, and for the materials if any to be taken therefrom, pay to them such compensation, either in a gross sum of money, or by monthly or other periodical payments, as shall be agreed upon in writing between him and such persons respectively. 3. In case the collector and the persons interested differ as to the sufficiency of the compensation or apportionment thereof, the collector shall refer such difference to the decision of the authority. Section 82. Power to enter and take possession and compensation on restoration. 1. On payment of such compensation, or on executing such agreement, or on making a reference under Section 64, the collector may enter upon and take possession of the land, and use or permit the use thereof in accordance with the terms of the said notice. 2. On the expiration of the term, the collector shall make or tender to the persons interested compensation for the damage if any done to the land and not provided for by the agreement, and shall restore the land to the persons interested therein, provided that, if the land has become permanently unfit to be used for the purpose for which it was used immediately before the commencement of such term, and if the persons interested shall so require, the appropriate government shall proceed under this Act to acquire the land as if it was needed permanently for a public purpose. Section 83. Difference as to condition of land. In case the collector and persons interested differ as to the condition of the land at the expiration of the term, or as to any matter connected with the said agreement, the collector shall refer such difference to the decision of the authority concerned. Chapter 12. Offences and penalties. Section 84. Punishment for false information, mala fide action, etc. 1. If a person, in connection with a requirement or direction under this Act, provides any information that is false or misleading, or produces any false document, he shall be liable to be punished with imprisonment of either description for a term which may extend to 6 months, or with fine which may extend to 1 lakh rupees, or with both. 2. Any rehabilitation and resettlement benefit availed of by making a false claim or through fraudulent means shall be liable to be recovered by the appropriate government in the manner as may be prescribed. 3. Disciplinary proceedings may be drawn up by the disciplinary authority against a government servant, who if proved to be guilty of a mala fide action in respect of any provision of this Act, shall be liable to such punishment including a fine as the disciplinary authority may decide. Section 85. Penalty for contravention of provisions of Act. If any person contravenes any of the provisions relating to payment of compensation or rehabilitation and resettlement, every such person shall be liable to a punishment of 6 months which may extend to 3 years or with fine or with both. Section 86. Offences by companies. 1. Where an offence under this Act has been committed by a company, every person who at the time the offence was committed was in charge of, and was responsible to, the company for the conduct of the business of the company, shall be deemed to be guilty of the offence and shall be liable to be proceeded against and punished accordingly, provided that nothing contained in this subsection shall render any such person liable to any punishment if he proves that the offence was committed without his knowledge or that he had exercised all due diligence to prevent the commission of such offence. 2. Notwithstanding anything contained in subsection 1. Where an offence under this Act has been committed by a company and it is proved that the offence has been committed with the consent or connivance of, or that the commission of the offence is attributable to any neglect on the part of any director, manager, secretary or other officer of the company, such director, manager, secretary or other officer shall also be deemed to be guilty of that offence and shall be liable to be proceeded against and punished accordingly. Explanation. For the purposes of this section, a company means any body corporate and includes a firm or other association of individuals in a requiring body, and b. Director, in relation to a firm, means a partner in the firm. Section 87. Offences by government departments. 1. Where an offence under this Act has been committed by any department of the government, the head of the department shall be deemed to be guilty of the offence and shall be liable to be proceeded against and punished accordingly. provided that nothing contained in this section shall render any person liable to any punishment if such person proves that the offence was committed without his knowledge or that such person exercised all due diligence to prevent the commission of such offence. 2. Notwithstanding anything contained in subsection 1. Where any offence under this Act has been committed by a department of the government and it is proved that the offence has been committed with the consent or connivance of, or is attributable to any neglect on the part of any officer, other than the head of the department, such officer shall also be deemed to be guilty of that offence and shall be liable to be proceeded against and punished accordingly. Section 88. Cognizance of offences by court. No court inferior to that of a metropolitan magistrate or a judicial magistrate of the first class shall be competent to try any offence punishable under this Act. Section 89. Offences to be non-cognizable, notwithstanding anything contained in the Code of Criminal Procedure, 1973, every offence under this Act shall be deemed to be non-cognizable. Section 90. Offences to be cognizable only on complaint filed by certain persons. No court shall take cognizance of any offence under this Act which is alleged to have been committed by a requiring body except on a complaint in writing made by the collector or any other officer authorized by the appropriate government or any member of the affected family.